Here's a question that sounds simple until you actually think about it. Can a temple ban women? Not as a policy question, as a constitutional one. Because in 2018, the Supreme Court of India had to answer that. 5 judges, 1 dissent. And the majority opinion contains an argument so analytically radical that most of the coverage completely missed it. This is about Sabarimala and about what the Constitution actually promises. Sabarimala is a temple in Kerala dedicated to Lord Ayyappa, who is believed to be a Naisthika brahmachari, a perpetual celibate. The temple's position: women between 10 and 50, capable of menstruation, must be kept out to protect the deity's celibacy. This practice was backed by Rule 3B of the 1965 Kerala Hindu Places of Public Worship Rules, which allowed public temples to restrict entry based on custom. The court's majority, 4 out of 5 judges, struck this down. The operative reasoning: Rule 3B is ultra vires, the Parent Act, which says all Hindus must have equal access to public temples. Women are Hindu. The ban falls. That's the clean legal answer. But Justice Chandrachud went further. And that's where it gets interesting. The majority's most striking argument is this: the Sabarimala exclusion is not just a violation of religious freedom or equality. It is structurally a form of untouchability. Here's how Chandrachud built the case. The Constitution deliberately left untouchability undefined in Article 17. It says untouchability shall be abolished in any form. Why any form? Because the drafters knew that the logic of ritual pollution, the idea that a certain body in a certain state makes sacred space impure, could be applied to more than just caste. K.T. Shah, in the Constituent Assembly, explicitly said women are treated as untouchable in certain periods. That language didn't make it into the final article, but the phrase "in any form" did. So Chandrachud said, the same purity and pollution logic that kept Dalits out of temples is the logic being used here. A menstruating woman is being constructed as polluting. That is untouchability. Article 17 abolishes it, not just caste-based untouchability, but the logic itself. The temple also argued that the deity's celibacy is an essential religious practice. Chandrachud's response is almost elegant in how it dismantles this. Your deity is celibate, fine, but you're saying women's bodies are a cause for deviation. You're making women responsible for a man's, or in this case, a deity's spiritual state. That is a constitutional stereotype. It doesn't become defensible because it's dressed as religion. The lone dissent came from Justice Indu Malhotra, and she was the only woman on the bench. Her argument is worth taking seriously. She said, faith doesn't have to be rational. Courts shouldn't use secular logic to evaluate the internal consistency of religious doctrine. If a community believes this practice is essential to their faith, and Malhotra found it was, tracing it to the Bhuthanatha Gita and centuries of consistent practice, then it deserves protection under Article 26, which guarantees denominations the right to manage their religious affairs. On Article 17, she disagreed sharply. The Constituent Assembly debates, she argued, show untouchability was meant specifically for caste-based discrimination against Harijans. The framers spoke of a specific, defined social evil. Extending it to women's menstrual status, she said, would be to stretch the provision beyond what it was designed for. The majority and the dissent are not talking past each other. They're disagreeing about the same deep question. When the Constitution says equality and dignity, does it override what a community considers sacred practice? Or does constitutional morality in a secular state require leaving space for faith on its own terms? The Sabarimala Judgement is a 4-to-1 majority. The ban is struck down. Rule 3B is gone. But the more interesting verdict is Chandrachud's the argument that menstrual exclusion is untouchability in any form. If that reasoning holds and gets applied consistently, it doesn't just affect Sabarimala. It affects every religious practice built on the logic of a woman's body being ritually impure. Whether you think that's exactly right or deeply complicated, and it is complicated, This case is the court saying, there is no space in the constitutional order where that logic gets to live unchallenged. The Constitution is supreme, even over custom, even over faith.